In 1775, Thomas Paine wrote a pamphlet stating that the freedoms of men can only be maintained by limiting the power of government. The pamphlet was called Common Sense, and today it still is common sense.
I'm Mark Zaccaria.
I'm April Giarrusso. This is Common Sense. Welcome back. This week, we have a strong lineup for you, and it's all heavily weighted towards the role of technology in government. You're about to get our take on transparency in government here in Rhode Island. You'll also hear about the plan to implement new technology in the voter registration process. We'll talk about the pluses and the minuses of legislation pending on that front. Then we will look at the slippery slope as we are on when technology is implemented without proper regard for privacy. Where is that line, and how do we know we've crossed it? As usual, this week's show will have an in-depth interview brought to us by State Representative Patricia Morgan. This time, Pat talks with Micheal Marcello, an attorney and her colleague in the House. Today, they'll go into tort reform at the state level. In between segments, Mark and I will reappear to pose our most pressing question: are you kidding me? Finally, our show will conclude with sage advice from commentator Jeff Richard. This week, Jeff continues his series on games with talk of what the future holds for hybrid parlor competition in the 21st century. To get all that started, let's have some analysis of several of the top news stories impacting life in the Ocean State as March goes out like a lamb. Mark?
Thanks, April. Recently, the theme of transparency in government has been played over and over again all across our nation. In fact, the Associated Press is observing what it calls Sunshine Week as a journalistic celebration of access to public records. In a story for their series, AP reporter Matt O'Brien, working from his post at the Milwaukee Journal-Sentinel, wrote a story on email availability from legislators here in Rhode Island. It's a complex issue, and Matt's reporting revealed that Ocean State Solons come down all across the spectrum of responses. 4 years ago, when the Rhode Island Open Records Law was strengthened, legislators blocked a provision which would have included complete access to their state emails. Some legislators on both sides of the aisle defend this exception on the basis of the many very private exchanges they have with constituents. The argument is that while the legislators have nothing to keep confidential, their constituents may discuss the specifics of legal actions, medical conditions, or hearsay evidence which should not be widely circulated. Even so, legislators may voluntarily turn over emails when asked, and a number of them do. In a recent AP request for email traffic in the Rhode Island Senate in advance of the Road Works vote, Republican leaders quickly complied while Democrats did not. This begs the obvious inference, which might or might not be true. It also suggests that email traffic between legislators should not be protected the way their communications with constituents have been. In this session, Senator Archambault has a bill submitted which would make all RI.gov emails public information unless they have, quote, no demonstrable connection to the exercise of official functions or influence, unquote. Sadly, there's no mention in the bill of which umpire calls balls and strikes to make that determination. Clearly, technology and the times are evolving faster than the rules of the game we play in government. This is another of those boring but important issues that we at Common Sense will keep up with, and you should too. April?
Thanks, Mark. Here's more on that very point. Last week, state senators voted on legislation that would create an online portal for electronic voter registration. The legislation passed in a 30-6 vote with Senate Republicans voting against it. Republican Senate Minority Leader Dennis Algier stated that Senate Republicans are in favor of the idea of online voter registration. However, they voted against this particular piece of legislation because they want more safeguards involved to protect against voter fraud. Governor Raimondo and Secretary of State Nellie Gorbea both support the measure, with Gorbea taking to Twitter to thank the Senate and promise to implement it if it becomes a law. Governor Raimondo fully expects to sign it in once it has been sent to her desk. But what if Algier and company are right? Would some sort of independent evaluation of the security of the process be in order before we implement it? Look, last year, the U.S. Department of Defense lost millions of Social Security account numbers, and the fallout in terms of identity theft is still being tabulated. Is the cybersecurity proposed in this bill sufficient to prevent hackers from registering everyone in the Toronto phone book just to demonstrate they can do it? I don't know. I bet you don't either. But shouldn't somebody be able to vouch for all the security tricks Rhode Island has learned since it put up its Obamacare portal? Mark?
Thanks again, April. As I said at the top of this segment, technology is evolving faster these days than are its considered and well thought through uses. Here's a two-part story that demonstrates the slippery slope we may be on. In this session of the Rhode Island General Assembly, there are several bills on file which would permit the Turnpike and Bridge Authority to exchange information with the Department of Motor Vehicles. The object of these proposed statutes is to provide a mechanism for holding up the driver's license renewal and vehicle registration process for those who have unpaid tolls. The Turnpike and Bridge Authority is set up to collect fees for passage on a real-time basis. They have neither the authority nor the procedures in place to dun scofflaws or to be a collection agency for overdue unpaid debts. The bills in this session of the General Assembly are very likely to coalesce into a single form and pass this spring. After all, we already use this same process to pressure those delinquent with their state income taxes. But what of all the toll jumpers who don't even have an easy pass, yet still sail through the electronic lane on the Pell Bridge? Should they not be photographed so they can be identified by their registration tags for a fine? Sure. But that brings us to our second story. RIDOT is underway with the design and specification of the 24 or so toll gantries they'll be erecting to support the ill-advised roadworks legislation. All of these devices will be optical. They'll be more than capable of tracking every vehicle that comes within range, comparing its tag number to any of a variety of databases, and then recording the date and time of the sighting for posterity. Should police agencies have access to these records of the comings and goings of vehicles they later come to suspect of use in a crime? Should the average annual mileage for any or all vehicles in the tracking pool be available to police? How about insurance companies who compute risk based on usage? How about the RI tax authorities who have already talked about a sliding scale road use tax? The point is, we need to control government costs so that traditional sources of revenue will continue to suffice. If we don't, there are very real privacy risks looming as the constant cry of roads and bridges will be used in ever more creative ways to justify the high-tech picking of our pockets while keeping us constantly under surveillance. April?
Thanks, Mark. That completes our analysis of the news this week. Before we move on to the first segment of Representative Patricia Morgan's interview, let's take time out for a look at what's still ahead in this week's edition of Common Sense. In fact, after that reminder, we may even take the opportunity to ask our favorite question, are you kidding me? Of course, you've heard all about the Stop Tolls effort that was made by legislators and private industry groups here in Rhode Island. No doubt you've also heard that the tolling plan was forced through the legislature anyway and signed by the governor in the rotunda just minutes after final enactment. But did you know that House opponents of the measure were forced to submit formal Freedom of Information Act requests to get any information on the plan? Then these elected officials were actually invoiced by DOT for the time and effort needed to fulfill those requests? Are you kidding me? Hey, it's one thing to disrespect the taxpayers who will have to pay hundreds of millions in extra indirect taxes when these toll gantries are cranked up. But it is quite another to insult members of the legislature by charging them hundreds of dollars to get readily available information from your archives. Do you remember the flap last summer about the pre-Civil War map of Providence that was supplied in answer to a request for the locations of the toll gantries? I wonder how much they charged for that piece of the package. I'm sorry, but I think there are only two options to explain what's going on here. One is nonfeasance. That's when one hand doesn't know what the other hand is doing. So something stupid happens when no one is really looking. The only other thing it could be is malfeasance. That is knowing full well what the right thing to do is, and then doing something else. So, do you think even our state government is so inept that they'd send an invoice after filling a legislative request? Neither do I. Are you kidding me? Coming up, we will have an in-depth interview brought to us by State Representative Patricia Morgan. This time, Pat talks with Representative Micheal Marcello about tort reform. Mark and I will drop in occasionally to pose our most pressing question, are you kidding me? Finally, our show will conclude with sage advice from commentator Jeff Richard. That's what we have for you, Rhode Island, so stay tuned for some common sense.
Welcome to Common Sense Rhode Island. This is a program where we try to make sense out of the policies that affect your life and come up with common sense solutions. I'm Representative Patricia Morgan, and we have with us today Representative Micheal Marcello from District 41, which is Scituate, Cranston, those two.
Yes.
And he's also a practicing lawyer.
Yes.
That's what you do.
But I'm not in the legislature.
Yeah, to actually support his family. And today we're going to be talking about tort reform. This is not medical tort reform. This is about the other kinds of suits that come up in court. And this particular, the three bills that Mike and I have put in are about improving the economic climate in Rhode Island. And we've been doing this now for quite a few years. At one point I thought we were making some real progress. But it is really important, and it's important for average Rhode Islanders who want to have good jobs here and want to see our state thriving. So, Mike, you've put in two of these bills, and I know you've been really a champion of this. My understanding is you were a lawyer who did criminal or defense.
They call it civil defense. So it's the civil system. It's not the criminal system. It's the civil litigation system within our state.
Okay, and what kinds of cases?
I would represent people who get sued. So they could be policyholders, people who get in a car accident. They could be businesses who get sued. It could be a construction company who gets sued for damage to on a property. It could be anything. Someone who slips and falls out of McDonald's or Dunkin' Donuts. Anything like that. So it's not criminal, it's all civil. So where you're trying to get money damages based upon a generally negligent standard. So it could be legal malpractice, it could be any number of things like that.
Okay, and it can be municipalities as well.
Yes. I represented a lot of cities and towns and who get sued for a lot of different reasons. Trip and fall on a city sidewalk, those kind of issues, yes.
Okay, so why is this important?
Well, civil justice is one of the things that people really, that affects our lives every day, but we don't really think about it. But the litigation climate within a state is very important to determine whether or not, one, people are getting treated fairly, whether or not they actually have access to the court system, and number two, once they do have access to the court system, what are the outcomes? Is it a fair system? Is it based upon good laws? Is it based upon generally accepted rules of practice or standards of legal precedent, or is it based on something else? So it all melds together, but it is a very important system, and it's a very important, we solve business disputes in our country not by having fights on the street or having boxing matches.
That's a good thing.
Right? Yeah. We go to the court system. So once we set up a court system, the issue is what laws govern how that system works.
And to make them fair for all the parties that come there.
Correct.
All right. I know during the testimony that we had was it last week?
Yes.
There was a gentleman who came to talk on behalf of municipalities who often get sued.
Yes. So
it's a big problem for them.
Correct. They get sued, and because of the way the system is set up now, the statute of limitations for cities and towns, depending what the case is, usually about three years before you can file a case. But cities and towns can get prejudgment interest against them up to a certain amount. So it does affect them, how long it takes to get to court and how long the case.
He was saying it really it changed the way municipalities even fought some of the claims.
Correct.
Our current set of laws.
Correct.
That are on the book.
Correct.
And it drives then their premiums, which drives.
Correct. So the best example that I can give you is from a insurance perspective. So most of my clients when I was in private practice were insurance companies or policyholders, and they base their premiums on the litigation climate which you're practicing. And Rhode Island has a very high, what they call a prejudgment interest statute, which runs at 12% from the date of the accident or injury that gives rise to the cause of action. And I can tell you that I've talked to adjusters across the country, from Texas, Arizona, where all these insurance companies are located, Illinois, Hartford, Connecticut. When they hear about the prejudgment statute in Rhode Island, they're like, wow, that's crazy. Why is it so high? This makes no sense. sense, and it did affect not only the amount of premiums they charged, but how we actually litigated the case. Whether we settled more quickly, or we fought a case, but then it became so onerous to fight it because it would take 3 years to get through the whole system that the company would say, you know what, it's not worth it. We know this is a winner, but at the end of the day, we could get a small damage award, but we're going to tack on all this prejudgment interest. So it does have an effect on how people litigate.
I guess it was 2 years ago, I had one of our assistants, excuse me, in our office actually go to the court system and pull up a lot of the suits that had appeared in the different courts. And we actually found instances of where the interest was more expensive than the award.
Right. So let's clarify what we're talking about. We're talking about prejudgment interest, which is an amount that's added on after a judgment is rendered by a jury. So, and in Rhode Island, it runs at 12% a year from the date of the injury, which is a huge amount. So you can't get 12% anywhere in a bank.
You certainly can't now. It's about 1/4% right now.
Right, exactly. So you can't get that anywhere. I always say, the court system or a lawsuit shouldn't be the best investment Rhode Islanders can make. So it is an onerous rate. It was put in the 70s and 80s when interest rates were high, and there was a delay in getting people the money they needed, and it was really meant to reward or compensate people for the lost value of time of money. In other words, they get injured today, and it takes 3 years to get their money or their judgment, and therefore we have to compensate that for their lost time. That's when interest rates were 18-21%. It was put in during that period. Interest rates are no longer that high, and we've never gone back to lower that interest rate. So now you've got what I consider unfair interest rate that really punishes not only policyholders, but anybody who does business in Rhode Island.
Well, and again, going back to that study that we did, I think we found some awards that were around $10,000 or something like that, and the interest ended up being $15,000 or $18,000. It was just foolish.
So I can give you a personal experience. I was trying a case. It was a rear-end car accident, and what happened was the person got injured, and we had made what we thought were reasonable offers, and for whatever reasons, again, the defendant doesn't control how the case gets put to court. We're always reacting to what the plaintiff. So they filed the case around 3 years near the expiration
towards
of the statute.
Towards the end, sure.
Near the end of the statute of limitations, and then it takes another 3 years to get to court. Get through the pretrial discovery and all that stuff, depositions, discovery, medical records, and whatnot. So now you're looking at 6 years of interest at 12%.
72%.
And then you wait a little longer for scheduling and other things. And we had offered what we considered, fair amount, and I was pleased that the jury came back and awarded about $7,500 in damages. The problem was the interest rate was 100%. So he got double. He got double.
So instead of $7,500, it was $15,000.
Right.
So why is that important to average folks out here?
Well, one, it's reflected in their insurance premiums.
Premiums go up.
Premiums go up when their interest rates are higher. And number two, it's just an issue of fairness. I mean, we shouldn't be compensating anybody based upon an interest rate that's really no longer based on anything. It was based upon the time value of money. It's bad public policy to keep it at 12% when interest rates are, 0.8%.
Yeah, exactly. So we're going to continue this conversation. We'll be back in just a moment.
Nicholas Delmenico sniffed last week in his blog on RI Future that the Providence Journal had participated in what he called a nationwide blackout on the campaign of Senator Bernie Sanders for the presidential nomination of the Democratic Party. Delmenico's colleague Bob Plain used his blog space the next day to take the paper's executive director, David Butler, to task on Senator Sanders' behalf. Poor guys, they're getting no love from Projo. Are you kidding me? Nicholas Delmenico's original gripe was that the Sunday edition didn't mention the margins of Sanders' wins in the primaries in Kansas and Nebraska, nor that of his very narrow defeat in Louisiana. Plain's follow-up contorted Dave Butler's explanation. The editor had asserted that the facts of the Sanders Saturday performance had been listed in an Associated Press summary, run well below the fold. Bob took that as an apology and ran with it in RI Future. I hope his regular readers were impressed. My takeaway was that these Rhode Island socialists were righteously indignant at what they thought was really unfair reporting. Well, boo-hoo, boys. Welcome to the real world that those of us on the right have inhabited for decades. Apparently, these guys have just figured out that the mainstream media has an axe to grind, and they have no problem letting their bias govern their editorial decisions. In the immortal words of actor Claude Rains playing Captain Louis Renault in the classic film Casablanca, "I'm shocked, Ricky, shocked! There is spin going on here." Get used to it, lefties. If you believe in your product, you'll just have to work harder selling it. Hey, it could be worse. You could be Republicans. Are you kidding me?
Red team, listen up. It's Mark from the bunker. Hey, you could laugh about me manning this listening post in the basement of the Rhode Island State House, but you hear things, okay? Just yesterday, I was crawling on my belly like a reptile through the ventilation system, and what did I hear in the governor's office? She's talking to one of her staffers, and she says, we gotta figure out a way to get the youth vote out in November so this guy Trump doesn't win Rhode Island. Well, staffer says that's easy. Let's put a referendum down there about marijuana legalization. Governor liked the thought, but she said, hey, I can only make it a non-binding resolution. Staffer shrugged and said, go ahead, just don't tell him till after. You know, that kid got a $10,000 raise on the spot. Now you know what I know. It's Mark from the bunker. Out.
Welcome back. I'm Representative Patricia Morgan, and today we have with us as our guest Micheal Marcello from District 41, which is Scituate and Cranston.
Yes.
And we're talking about tort reform, and this is really important to you because it really affects your insurance premiums and affects our business climate here in Rhode Island. We were talking about the fact that right now, while a case is going on, a 12% interest rate is being added onto any future judgment.
Correct.
Am I saying that right?
That's basically what it is, yes.
Okay,
Yep.
so from the time you have an accident until it's settled, it's 12% a year that is being added onto anything that you get.
Settled or judgment or an arbitration award, yes. So right.
All right,
So it's part of it. Yes, it's a part of a calculation that goes after that the clerk of the court will put on after a jury verdict is awarded or after an arbitrator awards an award. Yes.
So after you settle it, or after an arbitrator steps in, or after a jury says.
Correct. Well, you know, the settlement is when you settle the case, you just settle it for X amount of dollars.
You make an offer.
You make an offer and they accept it. In part of those settlement negotiations, you always calculate a little bit about, well, if this went to trial, how much would the prejudgment interest be? And so that becomes part of the settlement negotiation. So you kind of roll in that number into a settlement. But it really comes into play when you get a final judgment by a jury or an arbitrator who awards an award.
Okay.
Damage award, yeah.
All right, and as I was saying to you, we actually went to the different courts. We pulled up all of the cases, and what we found, I thought, was really troubling in that people were waiting until 2.5 years after the incident happened to even tell the defendant or the
defendant.
Defendant. Am I saying it right? That something had happened and that they were intending to sue.
So they waited about 3 years until they filed, which in Rhode Island is the statute of limitations for personal injury action. So you can wait 3 years. So you can get in a car accident today, and I can wait 3 years to file against the
which would mean
defendant.
36% even before the person knows they're going to be sued.
Correct.
Right?
Yes.
So I know that the trial lawyers have come back and said, no, the 12% is important because it encourages the defendant to act quickly.
Correct.
To get the people who have been injured their money. But what I saw was people were waiting years.
Right.
to even tell them that there was an injury.
So my experience is, if you have a good case as a plaintiff's lawyer, you file that case right away, and you want to get the medicals in, you want to get everything done
And
quickly.
get the people taken care of.
Exactly. If it's a marginal case, where it's a rare accident, maybe you have some soft tissue injuries, maybe $2,000 of medicals, it's worth your while to wait that 3 years, because no matter what a jury awards, you're going to get 36% interest on it from the very beginning. And of course, the plaintiff's attorney gets a third of it, of all recovery.
So if he waits, he gets his fee taken care of.
Exactly. He gets more of a third than normally he would have.
Okay.
So I mean, the courts have said repeatedly in Rhode Island that one of the purposes of the prejudgment interest statute, and that's 12%, is to encourage settlements, and that's fair. I mean, I think it does in some instances. It does encourage settlements, but the vast majority of instances, in my experience, is it really, excuse me. It is the marginal cases that are not being filed, and it's causing the value of those cases to be much higher than what they normally would be. So that's really what the problem is. Now, again, we're talking about 12%, 1% a month. So if you were to say we cut it down to 6%, which my bill does that mean you're less likely to settle by a factor of 1/2? I don't think so. I mean, 6% is still a good number.
It's still a good number,
It's still a good number. So what's the magic number? If it's truly...
And if it's a good case.
Right.
Right? If you know that the damage was legitimate and the people need to get some kind of compensation for that, you're gonna act to get it done.
Exactly. It's not any benefit for the defendant to wait
at 6% or 12%.
Exactly. The converse of that is, I always tell my friends in the plaintiff's bar, and they're all good attorneys. Well, does that if the purpose is to encourage settlement, why don't we then make it 100%? Why don't we make it 50% interest? At some point, the number has to be so unrealistic that it doesn't make any sense. And I think that even in that point, the courts would step in and say, well, that's a little bit much. It's really now...
That's too heavy-handed.
It's too heavy-handed.
But 12% is heavy-handed.
Absolutely. I believe 12%, as I said, was based upon the interest rates when the statute was put in the 70s and 80s. And now that interest rates have dropped, most states link it to the prime rate, 3% plus the prime or something like that. That's a fair way to do it. But for even administrative ease, I just picked a 6%. It could be 8%, it could be 10%, but 12% is a high number in my opinion.
12% is because
and it needs to be adjusted.
People will make settlements on cases that they probably should be fighting.
Correct.
Right.
And it does happen. It does happen that...
Let's just get it over with because the clock keeps ticking.
Exactly. Only a plaintiff can tell you when the case is filed. Plaintiff drives generally the pace of a case, and when you see someone dragging along like that, then sometimes the companies just say, look, we don't want to incur this interest anymore. We've got to get rid of this case now, and they settle it. And so cases that probably should be tried are not, and then some cases, again, cases that usually go to court are cases where the liability is in question or the damages are in question. So you can't come to an agreed number, and that's fair. And that's what the jury system is for. But to then tack upon that 12% interest on any judgment that the jury never knows about. I mean, you cannot, and the lawyer from either side can never tell the jury that, by the way, whatever award you give, there's going to be tacked on automatically by the clerk of the court a 12% interest rate from the date of the...
Per year. And by that time, you're right, it might be 5 years in.
It could be 60%. I mean, I've had cases where it's been 100% interest. I mean, it's how
long it has taken.
Yeah. And sometimes sometimes it's the court system, sometimes it's the plaintiff's counsel, sometimes it's a combination of both. But again, I just don't think that 12% is a realistic number, and it does have the effect of making Rhode Island an outlier in the litigation. This is not a radical change. We're not talking about doing away with 100% comparative negligence in our state, which is another issue that we could discuss. This is really just a procedural interest rate that can be lowered today if we wanted to do so.
And you chose 6%. You said some states actually added as the standard interest rate plus?
Yes, so the prime plus 3%. I mean, all states are all over the map as to what they use, but 12% from the date of the accident is the highest in the country as far as prejudgment interest rates.
So we're a bad outlier.
We are an awful outlier on that, yes.
And again, I just think that when you're a company And we have to have a good business climate here. Companies look at our litigation atmosphere to see whether they're going to be punished for being in Rhode Island.
Yes, I agree. I
Right?
believe that's true. I mean, I think big companies look at the litigation climate. I think all companies look at the litigation climate. But even if they don't look at the litigation climate, you need to know that 12% interest, prejudgment interest rate is looked at by insurance companies, those companies that insure businesses, insure policyholders in Rhode Island, and that becomes part of their policy premium. So,
Well, I know one of our colleagues, our former colleagues, used to own a bowling alley, and I mentioned this to him, and he rolled his eyes because anybody who opens their doors gets sued.
Right.
And you want to be fair. You want to make sure that people who are legitimately hurt get taken care of, but you also don't want to punish good
Right.
businesses who do everything right.
right, and it's important to note that the prejudgment interest rate, the courts have said repeatedly, that's not part of the damages. That's not a damage that the person is entitled to. It is really to compensate for the lost time value of money. So it's not really part of the fair compensation. It's really just part of an ministerial function to give them the benefit of that lost value.
Okay. All right, with that, we'll come back. We have more to talk about.
Rhode Island Attorney General Peter Kilmartin has convened a seminar on the law enforcement impact of legalizing marijuana in the Ocean State. The event is scheduled for next week at Brown University, and the list of presenters is rife with apologists and entrepreneurs from the emerging dopers service sector. Are you kidding me? I guess it's good to know that General Kilmartin can still find us up here. There's been talk recently the fitness entertainer Richard Simmons has disappeared, and it was feared he was being held against his will in his own home for weeks. For the AG, it's been years. Sarasota, I think. Anyway, welcome home. As for the seminar itself, it features officials from the Washington State Office of Public Policy, the Coalition for Responsible Cannabis Production, and Deputy Attorneys General from Colorado and Washington State. Maybe it's just me, but I'd say all these guys are pro-marijuana. Either they stand to make a bundle off of sales and services to this new retail segment, or they stand to save a bundle in police overtime and court costs in their public budgets. Viewers of Common Sense will know the name Mike Cerullo. He's the former East Greenwich Town Councilor and licensed psychotherapist who's the prime mover behind the local anti-marijuana group, What's the Rush RI? Mike offers plenty of clinical evidence of the physiological and psychological dangers of the doobies, and it seems no real public safety angle is being pushed during Mr. Kilmartin's event. So I guess the future of the Ocean State was predicted way back in the 1960s. Turn on, tune in, drop out. And nowadays, the government is here to help you do it. Are you kidding me?
All right, team, listen up. It's Mark from the bunker. My listening post in the basement of the Rhode Island State House. Hey, have you seen the papers today? Representative Edith Aiello is out all over all the weeklies and the Projo with an op-ed saying that we should be ashamed of cell phones because every time they ping a local cell, there's a record of it. She considers it a privacy issue, and she's going to bring strong legislation to the floor of the House to keep from having that information about people's comings and goings. Go, please. When did she become such a privacy advocate? What does she know about the Fifth Amendment? Cut it out. She voted for tolls. You know what those gantries are going to do? They're going to keep track of your car every time you go out for a loaf of bread. Hey, if you go out for milk and bread and it's not a big snowstorm, what are they going to say to you? Look, this is nuts. It's Mark from the bunker. Out.
Coming up, we will have an in-depth interview brought to us by State Representative Patricia Morgan. This time, Pat talks with Representative Micheal Marcello about tort reform. Mark and I will drop in occasionally to pose our most pressing question, are you kidding me? Finally, our show will conclude with sage advice from commentator Jeff Richard. That's what we have for you, Rhode Island, so stay tuned for some common sense.
Welcome back. I'm Representative Patricia Morgan, and we have with us today Representative Micheal Marcello from District 41, which is Scituate and Cranston.
Yes.
And we have been talking about tort reform, or civil
Justice reform.
justice reform. And Mike has put in two bills. 1 is about adjusting the interest rate that is charged on settlements before they're settled.
Correct, which is tacked on by the clerk of the court once a judgment is rendered by a jury or an arbitrator.
Okay, and right now it's 12%. And
Yep.
and that actually drives our insurance premiums and has a dampening effect for businesses in Rhode Island. So Mike has been working for a couple of years now to lower that to 6%. And in truth, most states have already gone through some kind of reform
Correct.
on interest rates.
Correct.
So we're really an outlier there, and it hurts our business climate. But right in line with that 12% is when the interest starts clicking.
Right.
Right?
Yes.
So tell us about your second bill.
Okay, so under current Rhode Island law, the interest starts clicking from the date of the accident, or the date that you reasonably discover the accident. So if I get in a car accident on the way home today, the interest from that injury will start as soon as someone hits my car.
Okay.
Okay, and then I can wait. Then if I go to a lawyer and I tell them about my accident, and they have 3 years to file from the date of the accident for the statute of limitations. That's what a personal injury statute of limitations is in Rhode Island. So they can wait 3 years, which basically means the day that they go to the courthouse and file the suit, they've already tacked on 36% of prejudgment interest.
All right, so you get in a car accident, you go to a lawyer, he goes to the insurance company, the
First,
insurance
yeah.
company fixes your car.
Right.
But you say, well, I hurt my neck.
Right.
All right, if the insurance company says,
oh, maybe Mike, you had a pre-existing neck condition, this is your third accident, or you're really not as injured as badly as you say you are, or the medical records don't show it, so they can't settle the case for whatever reason, my lawyer will file suit in court.
all right, so the insurance company offers $10,000, you want $80,000.
Correct.
You can't come to a number in between.
Right, so then I have no other option but to file suit.
And they can wait
3 years from the date of the accident.
3 years, but the interest
Is ticking.
is being added
Correct.
on from the day that it started.
From the date of the accident, correct.
Okay, so, all right.
So that's at 12%.
Okay, at 12%. Now, trial lawyers will say that the insurance companies and defense lawyers, such as you were or are, you drag your feet.
Not my experience. In some cases where my experience has always been that those cases that get to me as a defense lawyer are those cases where liability is in question or the damages are in question. Either the cause of the accident is in question or the person is maybe not as injured based upon a lot of different things, pre-existing injuries, who knows what. So my experience is those cases that need to be settled by the insurance adjuster generally are. Those cases that get referred out to defense counsel for trial are generally those cases where there are some legitimate legal issues. Now, it would be, everyone thinks that, justice is blind, but justice is expensive. So, it takes a lot for an insurance company to refer out a case to a lawyer. They've got to pay now the lawyer, and they're going to wind up maybe paying a judgment to the plaintiff on this case. But the fact of the matter is, it's expensive. So now that it's in my hands or defense counsel's hands, I'm churning up legal fees to defend the case. But also overlaying all this is this prejudgment interest, because by the time it gets to a lawyer on the defense side, there's probably a good amount of prejudgment interest that's already accrued.
All right, so you're saying insurance companies really do like to get in there. The things that are legitimate, they really just like to settle them, because to not settle them, they're just adding more money onto the tab.
Correct.
Right, if it's going to be legitimate anyway,
right.
Just take care of the folks, make sure that their injuries are taken care of.
Correct. I mean, there's always an exception, but generally I think that's the case. And they're duty bound to have fair settlement negotiations by our Department of Business Regulations. So if they're found to be dragging out their feet or unwillingly delaying a settlement or not acting in good faith, the insurance company can be sued directly. So there is legal incentive for them to act fairly as well.
All right.
It's part of our laws.
But when they actually so the only things that actually go to trial are those things that they say, no, you're asking too much,
Correct.
Your injuries weren't that bad, we really don't think
Correct.
that you were injured in this particular case.
Or it wasn't our fault, it wasn't the defendant's fault, it was someone else's fault. So liability would be an issue as well.
Oh, okay. Now, in those cases, somebody can wait 2.5, 3 years to even say
File.
we're going to court.
Correct.
But in the meantime, they're getting 12% a year.
So my other bill,
They work together.
Right. So they worked in tandem. So I try to find a compromise. My other bill basically says, okay, I'll buy your argument that 12% helps settle cases quicker. Let's keep it at 12%. But let's make it run from the date that the actual file the suit, not from the date of the accident, but the actual date that the lawyer goes into court, files a complaint, and the interest will run from that date. So it automatically will stop the 3-year wait of the 36% during the statute of limitations. When you file the suit, that's when the interest begins to run. That's what Massachusetts does. Massachusetts keeps the 12% interest rate, which was adopted around the same time Rhode Island adopted its 12% interest rate, but they made it the date of the filing of the complaint, which is more fair, at least because at least at that point you know all the facts, or hopefully you know all the facts, and that everyone is now on the same playing field. No one benefits from delaying this case, because now that it's in suit, everyone has an incentive to try to get this case resolved. Get it done. So the clock starts ticking. Now, I will say that that's how most cases work in Rhode Island. It's from the date of the injury, except for medical malpractice cases. The medical malpractice lobby was very successful in saying, you know what, this is unfair to us. Medical malpractice injuries are sometimes difficult to determine. Causation is always an issue. When you discover them is always an issue. It's not like you're getting hit on a car accident and you know you get, right? So you could go have an operation today, maybe 3 years later, you determine that the doctor left the sponge in you, or something crazy like that. Yeah. But medical malpractice cases, the interest start at the date that they file the complaint.
But everything else is from the date of the incident.
Right. So my argument
Even if you've been talking all along,
Correct.
You've been talking with the insurance company, they fixed your car, they paid your medical bills, whatever.
Well, yeah, they wouldn't have paid your medicals, but generally, yes.
All right,
yeah.
okay,
Right.
Don't know that stuff.
Yeah.
Okay, so you've been trying, you've been talking, you've been trying to come to a resolution.
Correct.
And the interest is still accruing during that period of time?
Right.
So defense lawyers, if they don't have a good case, you're a defense,
Yes.
it's the other, what's that called?
Plaintiff's lawyers, yeah.
Plaintiff's lawyers, if they think they don't have a good case, there's nothing to compel them to move quicker.
If they have a case with minimal damages, like a fender bender rear end accident, it's to their incentive to wait 3 years, because whatever judgment they're going to get, they're already going to get 36% on that, or probably 60% by the time it actually gets its way through the court system. So a small damage claim becomes a big damage claim because of the interest.
But if you say the interest doesn't accrue until the day you sue,
there's no incentive for them to wait.
Right. It's really getting the money or whatever to the people who are injured.
It's just tipping the balance a little bit more in favor of the defendant's side, to let them say, you know what, we'll pay you the interest, but we're going to pay you from the date that you actually have your act together, you have your facts together, and you need to file a complaint. File the complaint, and then we'll talk.
Well, and obviously, that whole thing, everything we're talking about affects insurance premiums.
Yes.
And our insurance premiums in Rhode Island are not cheap. Not for individuals, not for companies, not for anybody.
There was testimony before the Judiciary Committee that on medical malpractice policies that doctors pay, 1% of it is 1% of their premiums goes to pay the interest rate that Rhode Island has. So I don't know what that would be for general automobile policies, but 1% is... It adds up. Yeah.
All right. We're going to take a break and we'll be right back.
Okay, you all remember Roadmap RI. You know it morphed into RI Rising. But that didn't fool anyone, so last year, Speaker Mattiello referred to the whole social engineering plan as shelved. Well, I hope that didn't give you a false sense of security, because now it's back. Are you kidding me? Nope, it's true. Now it's called RI Innovates. And the sneaky part is that it didn't arrive from statewide planning this time, but from the Brookings Institution. But don't worry, you still paid for all their labors on behalf of curtailing your rights. $1.3 million to be exact. RI Innovates has all the same features the AKA versions had. Forced concentration of population, differential taxation to herd folks in the desired direction, and a real distaste for privately owned vehicles. This time, the administration was pretty cute in how it tried to slip the thing through. At the press conference to showcase the Brookings findings, it was announced that Kevin Flynn and the boys and girls at Statewide Planning had already accepted the report's results. Did they mean accepted the plan? You bet. So last week, both the House and Senate committees had hearings on the plan just to take care of the nettlesome legal requirement that public input be solicited. What? You couldn't make it at 2:30 p.m. on Tuesday? Many of those who have no work made it. And by the way, it wasn't really a hearing because neither committee had to vote on anything. They just listened to the briefing and tried to stay awake. Requirement fulfilled. Folks, this is like state-sponsored terrorism. The hard-working, tax-paying men and women of Rhode Island have to stop what they are doing and successfully deal with these threats to individual and municipal sovereignty every single time. Meanwhile, the terrorists from the Smith Hill cell only have to succeed once, and everything changes. In fact, it looks like they may have nuked us this time. Are you kidding me?
Welcome back. I'm Representative Patricia Morgan, and we have with us today as our guest Mike Marcello, who is representative in District 41, which is Scituate and Cranston, and he's also a practicing attorney. So he has been, for the last few years, working really hard to get some good reform into our legal system, which is tort reform, tort meaning suits.
Civil suits.
Civil suits. And he's been doing it because we need a good, solid legal system, one that's fair, to keep our business climate strong and to help individuals in their homes as well. It's about being fair, and I think a lot of the things that you have proposed are really, really fair.
I mean, I don't think very many people don't realize the interaction between business and courts and the legal system, but that is one factor that people look at. What is the litigation climate within a city or town or within a state, and what's it like? What's the civil justice system like?
Right.
And we have excellent judges. You can get a trial in Rhode Island generally pretty quickly, but there are other legal stuff, that laws that are on the books that make it really onerous to defend a case in Rhode Island.
Well, and one of the bills that I've been putting in for a while is to reform joint and several liability. Already, I believe it's 41 states have already undertaken reform in this. Joint and several liability, how can we describe it to the folks? You're driving down the street, somebody up in front of you stops suddenly. There's a car between you and them. The second car plows into them because they're following too close, causes some damage. And you are following, you don't react quickly enough, and you tap the bumper of the second car. Turns out the middle car doesn't have insurance. But because you're the last car, you have the insurance, you end up paying for the damages of all three cars.
In general, it's a case where there are multiple defendants.
He's going to put it in legal terms for me.
So it's a case where there are multiple defendants, and that any one defendant who's found liable can be found liable for all the other percentage of liability of all the other people if they're either judgment proof, or in this case they don't have any insurance or anything like that. So
right. And in truth, the middle car might have caused 65% of the damage, and the last car might have only done 35.
Right, so let's assume that the first car...
But the last car doesn't only pay 35%. They can pay 100%.
They can pay 100% of the damages for every person who's injured, yes.
Okay, so that's not very fair for us as individuals if we're just tangentially caught up in something like that. Maybe we're 10% liable, but we end up paying for the entire accident. Imagine being a manufacturer. All right, and this is where it becomes hard on our business climate. You're a manufacturer, you have a widget, and the widget is misused and causes harm to somebody. You've just created the widget, you might be 1% liable. 1% liable. But because you have the big insurance policy, you're a company, you have more money, you can pay for 100% of the damages.
So let's assume that the person who manufactures the widget goes into a machine operated by another company, and that whole unit with your widget in it causes an injury to someone else. And the company that incorporated everything is either bankrupt or doesn't have insurance. So some person gets injured. Now your 1% liability because of your defective widget, you're going to own all the damages for a plaintiff who can prove their case.
All of the damages, right? So you
Assuming they're
can be
bankrupt,
1%, 5%.
Be 0.01%, yeah.
Yeah, just you happen to be there, and you can be drawn into this suit and end up
Right.
paying for all of it.
So many states have, as you know, and I think this is what your bill tries to do, many states have gone through a system
Thresholds.
called thresholds, or what they call proportional liability. You will only pay that percentage of a judgment which a jury finds you to be negligent. So in our case, with the widget, the plaintiff files suit, the jury finds that 90% of the liability is for the big manufacturer of the machine, and only 10% is attributable to your defective widget. You're only going to pay 10% of those damages to the plaintiff. That's it. You're
That's
done.
it.
You're capped. You're done.
10%. And so if you do everything right, your liability is limited by the
Your percentage of negligence.
percentage of negligence. That's, all right, so the term is joint and
It's several,
several.
yeah.
In that case, you take the joint out, and it becomes pure several.
Correct.
Right, where you only pay the amount that you are deemed to be liable for.
Correct.
And then there's the threshold, which is the bill that I put in this year, that you would have to be found 51% negligent before you would be asked to pay for the entire judgment.
That's another option, yes.
And that's what a lot of states have gone to. They've created thresholds of anywhere from 25% to 60%, I think, as a threshold. There are probably half that have gone to the pure several, and then another half of those that have undergone the reform that have put in thresholds or some variation between them. It just seems to me fairer, right? If you really haven't caused the damage, why would you have to pay for 100% of it? But also, it is a reform that especially if you're a manufacturer, if you make something, if you sell something to the public, I think it becomes really important for you to know that your something can't expose you to a huge amount of liability, even if you do everything right.
Assuming the case is brought in Rhode Island, that's correct, yes, yes. And this is probably the most business-friendly reform that we could do from the legal system. Joint and several liability is an ancient theory of law, and the fact that states have moved away from it over a period of time shows you that, the business climate, we're now an international manufacturing climate. We're getting companies from all over the country, from all over the world, manufacturing, shipping products. I mean, this is not the horse and buggy age when you've made something, you can only go to the next state, or maybe if you're lucky to the next state after that. Now we're an international economy where commerce is crossing the lines all the time. So it is one of those issues that really is a anti-business climate, and most states have moved away from it. When I first started practicing law in the state of Connecticut, that was 25 years ago, that they had just instituted what they could call proportional liability, and they had abolished joint and several liability. And that was, coming right out of law school.
That's a long time ago.
So coming right out of law school, I was like, wow, this is kind of fascinating. I had learned about it, the different systems that had been in place, but I actually had never been in a court system where they actually had implemented. So we were switching over from the old system to a new system, and I happened to be a law clerk, so I was happy, I was helping the judges help write decisions for these cases. So it was a very interesting model to follow. So I'm somewhat familiar with it. But Connecticut did it probably 25 years ago.
And we're still unable to do it.
Right.
And it just makes no sense when we're talking about really working on our economy and trying to get jobs here in Rhode Island, that we don't make this simple.
Yep. I tell all
And to me, it's just fair.
As you know, there are many lawyers in the General Assembly. Most of them are plaintiffs' attorneys. Some of us are defense attorneys. And I tell them all the time, even lawyers in the state of Rhode Island have an obligation to improve the business climate of the state of Rhode Island. And some of these reforms are common sense, not major reforms that would help improve the business climate within our state.
Right, and if you know what, you don't all have to be plaintiffs' lawyers then. You can actually be business lawyers and commercial lawyers,
Correct.
right? So that when you grow an economy, you grow it for everybody.
Correct. And everyone has a responsibility to do the right thing.
That's right. And I know they keep coming back and saying, well, this isn't fair. I can't say anything more unfair than making people pay for damages that they're not responsible for.
I think that ultimately, it's a gut issue. People, they could understand that. Why should I pay for something that is not my fault?
Yeah. So anyway, I want to thank you very much for putting in these reforms, and I hope that we can continue to work together and hopefully get them done sometime soon.
Someday soon.
Okay.
Thank you.
Yeah, thank you for coming.
Thank you.
Red team, listen up, it's Mark from the bunker. Hey, we used to live in the Ocean State. Now it's the Toll Road State. I can prove it. Look, we just heard from upstairs that Newport has lost a convention slated for 2018. It's the Trucking Association Executive Council from the Northeast sector. Okay, whatever that means. It's 200 people that were going to party hardy in Newport for a couple of days. The association says 200 plus people would be there, and they claim it to be worth $250,000 in overall business. Hey, divide one by the other, that's $1,000, $1,200, that's $1,250 per person. You can't get a hotel room for that in Newport. There's a lot of money at stake, so we're talking 15,000, 20,000 truck tolls before you make that up. And this is just the first of them, folks. We're the Toll Road State. Get used to it. They're gonna go elsewhere. This is Mark from the bunker. Out.
Now, I guess I understand why daylight saving time came to be. And I should be happy because I get to stay on the golf course a little longer in the afternoon. But on the downside, I get up in the dark and wait, sometimes patiently, for enough sunlight so the dogs can do their morning walk, the best part of their day. And of course, the newspapers that used to come at 5:30 now come much later. It is all very unsettling. If you check in with the wiki folks, you'll learn more about the history of daylight saving time than you probably want to know. There were several comments I found entertaining. Some in 1984. Fortune magazine estimated that a 7-week extension of daylight saving time would yield an additional $30 million for 7-Eleven stores. And the National Golf Foundation estimated the extension would increase golf industry revenues $200 to $300 million. Interesting. But over the years, all aspects of daylight life have been examined, so we really do know what happens. In the final analysis, the give and take of the political process has resulted in different decisions across the planet. Some nations use it and others do not. Here we have chosen to spring forward and fall back. Now, the wiki folks organized their discussion of daylight saving time so that its long history is exposed, and I liked the politics section. Seems the prominent English builder, outdoorsman, and avid golfer William Willett proposed daylight saving time in 1905 in England. He disliked cutting his round of golf short at dusk. Eventually, his proposal got to Parliament for discussion, but just like the Rhode Island way of governing, it didn't get out of committee. But the ball was rolling, and eventually the argument for daylight saving time won out. Then the 1970s saw daylight saving time widely adopted here and in Europe as a result of the energy crisis. Actually, the wide world has not adopted a uniform system, so if you are an international traveler, good luck. Now, I wonder if our very smart phones know when they cross time zones and what each time zone has done with daylight saving time. Now, that's more than I need to know right now with no traveling in my immediate future. On the immediate impact of daylight saving time at my house, besides the dogs and the papers, it's the clocks. We have all sorts of clocks scattered around the house. Over the last 46 years of wedded bliss, my wife and I have acquired a vast assortment of timepieces. Ever since I put all my wristwatches in the drawer, I have relied on the casual glance throughout the house to gauge the time. I really like to be on time, so I'm always looking around for the time of day. Our dining room, still have one, has a lovely wind-up clock made by the New England Clock Company. Now, we bought it very early in our marriage. I only wind it up occasionally when someone is coming to eat at the dining room table. That room also has a very pretty and expensive Howard Miller clock. We bought that one for my son when he got married. Some years later, I found it stored in his basement, and I reclaimed it. Didn't match the decorum of their house. We have 2 clocks in the living room, one made by my youngest in the woodworking class at Portsmouth High School. The other was a needlepoint clock lovingly crafted by my mother-in-law. Now, we will always have those clocks. The family room has 2 clocks, one on the wall and one on the fireplace mantel. The mantel clock was made by my father-in-law. Both of these clocks in that room run on batteries. So in the spring, I pull them down, adjust the time, but you know, when something sits around for a long time, it and everything around it are dirty, so they have to be cleaned. And maybe I need to put a new battery in. The kitchen has a wall clock, the stove clock, the microwave clock, and the Bose Wave radio clock. All of them need 2 annual adjustments. The finished basement has 2 battery wall clocks and a Bailey, Banks, and Biddle wind-up chimer that also doesn't get wound up very often. Now, the 4 bedrooms in the house all have nightstand clocks, all 4 having different settings and systems to move the time around. So the grand total of timepieces is, at my house, 18. 16 of them need to be adjusted. Short of being an actual collector of clocks, and there are many of those folks in America, I think we must be pretty far ahead of the average American home for clocks needing time adjustments. I would actually vote to get rid of daylight saving time. Thank you for watching, and God bless.